Hello, everybody. Welcome to our Navigating the Norm panel. I'm really glad to see you guys here with us today.
Hi, my name is Lee Morin, and I am an attorney in Old Fourth Ward near downtown Atlanta. And I have a law firm, Morin Entertainment Law. You might see the sign behind me here. And I've been working with Ginger since 2015. And I've known Andrew, well, since the 1990s. So, but I've been working with the video game community since 2013. So altogether, that's about 12 years combined. And I've had the privilege of being able to speak at Siege, of being able to speak at ASIFA, the conference, and the International Animation Fest. I've attended that. And I've met so many animators and video game designers. And I've really enjoyed getting to know all of you and your businesses very, very much. And so I specialize in intellectual property, finance, corporate finance for entertainment startup companies, as well as freelancers, independent contractors, and talent, essentially. So it has been my privilege to get to know these attorneys that I'm about to introduce to you better. And some of them I've known for quite a while. I'm really excited that you guys get to hear from them today. They're very, very good at what they do. And they're going to talk all about the stimulus package legislation. But before we get into the first question, I would love it if each of our speakers could give us a little bit about yourself and why you're here today.
Thanks, Lee. Hi, guys and gals. My name is Jason Wiggum. I am a partner at Wiggum & Gear in downtown Atlanta, and I am a tax attorney. I specialize in helping individuals, independent contractors, self-employed folks, and businesses, small business-sized businesses, resolve their tax liabilities. So when someone has a tax issue and they need to dispute it, or if they can't pay it, I help them with that. I've known Lee for a number of years, and when Congress passed the Stimulus Act, the CARES Act, I put hard into helping my clients maximize those benefits, and I'm happy to be here. Thanks.
So my name is Scott Whitman. I am a labor and employment law partner at Barnes & Thornburg in Los Angeles. I've been practicing probably for more years than I care to admit, probably more than anybody else on the panel. My first case right out of law school involved an animation company and a union organizing campaign at that company. And my first trial was defending an animator in a lawsuit. And so that goes back to about 32 years worth of experience in the animation industry. I've been involved in the video game industry for probably about 12 years. For much of that time, I represented a group of video game employers who negotiated the interactive media agreement on the industry side across the table from AFTRA and SAG, and most recently SAG-AFTRA. So I've got a fair amount of experience in both animation and in video games. And my practice is dealing with both the union side of things and the labor and employment side of things on labor law. So, and being in California, that's always a challenging proposition.
I'm a corporate and intellectual property attorney who's been practicing almost as long as Scott. I represent a wide range of clients, including software developers, gaming companies, game developers. One of my clients at one point was a leading Flash developer, which was an interesting to go through the transition from Flash, and she remained active long after everyone else had sort of walked away. So that was fun. And my practice is very diverse depending on the client. So I do corporate intellectual property. I jumped on the stimulus early because I'm an optimist, and I was hopeful that it would prove to be beneficial for the economy and for companies alike. And we'll discuss it more in detail shortly.
Okay, first question. Let's discuss this 3-parts package. Okay, we have 3 different stimulus bills that passed, and all at different times, but all in the same month. We can start with Nancy. I was one of the lucky recipients of Nancy's memo, which we have provided to GGDA and ASIFA as a handout for this event. So you should be receiving that. Nancy, if you will, talk about your impressions of the intent of this legislation from your perspective, keeping in mind the businesses that you serve.
Right. So it's an interesting situation what happened when COVID-19 hit the U.S. shores. Due to a variety of factors, we were literally caught unprepared and off guard for no good reason. And I don't think anyone could have anticipated what a tsunami until you've gone through something like that. And so the government scrambled to try to figure out solutions that would prop up businesses, protect employment, serve a lot of purposes. It's a very broad-ranging set of legislation that takes care of everything from unemployed independent contractors for the very first time to airlines, and happily not cruise ships. And because they all chose to go offshore to avoid U.S. taxes. So I was very optimistic with the options that were available for everyone from independent contractors who run their own companies and run it like a company. And so they could go for the Paycheck Protection Program, or they could opt for the unemployment option through unemployment insurance for the very first time. I forgot the percentage of people, but it's some huge percentage of Americans are technically independent contractors. And historically, they're not counted toward unemployment. So there was some flexibility, there were some options, but the Paycheck Protection Program ended up being drafted in a way, well, there were 2 things that happened. It was drafted correctly, and then the Small Business Administration under Steve Mnuchin's leadership made some very tactical decisions that in many ways negated its efficiency and efficacy out of the box. And we saw some horrible examples. I have a client, not in tech, not in anything, and about as old school as you can get, agriculture, that has banked with Bank of America since the bank started in Northern California. And Bank of America denied them the PPP because they didn't have a line of credit already established with the bank. So it was shocking, it was depressing, it was demoralizing. And thanks to the internet, it didn't go unnoticed. And the second round was more efficient, was more equitable, and really has saved a lot of businesses. And as people may know right now, the Congress has passed a really sweeping reform to the way the PPP is going to be treated. It has not yet been signed by the person who has to sign it. But hopefully that will get done, and it will change dramatically how the PPP will actually be used in reality.
Nancy, thank you for that information on the PPP. Does Jason or Scott, either one of you, feel free to jump in, want to discuss a little bit about how the stimulus package in particular struck you with regard to your particular specialty, either with regard to employment or with tax? Scott, why don't you start with that?
Yeah, I'll jump in. I was just going back over some old PowerPoints. My firm has been doing a COVID or had been doing a COVID webinar weekly from about the middle of March to I think last week. And this week was the first week we've skipped because the developments have slowed down, and we were running out of new material to talk to. But we ran, I think, 11 straight weeks of an hour and a half seminar covering everything from labor and employment to immigration issues to tax issues to OSHA, you name it, we covered it. Some small business administration PPP issues because everybody was going for the bailout loans. And my area of expertise was labor and employment, and I ended up getting stuck with a lot of the litigation. And at the beginning of all of this, which goes back to about, I want to say March 22nd or 23rd, you were drinking from a fire hose. And I was looking at my slides from early presentations, and basically I was starting with the Families First Act, and basically I said, this is last week's news, but this is entirely new to you because by March 23rd or whatever it was, March 20th maybe, the law was introduced in the House of Representatives on March 11th. It passed on the night of the morning of the 14th. It passed the Senate 2 days later, or it was amended 2 days later and passed the Senate 2 days after that. And so on March 18th, you had the Families First Act, which was designed to help workers who were working for companies while COVID was going on. And then the next day, California shut down the entire state. Governor Newsom issued an order requiring everybody to stay home. And all of a sudden, everything with the Families First Act kind of got thrown out the window even before it ever came to be in effect, because it didn't go into effect until April 1st. So unless you were an essential employer, your employees couldn't take advantage of the Families First Act until the restart happened. And so almost as soon as the shutdown started, then the CARES Act started making its way through Congress. Nancy indicated it's been amended. I think it's been amended now twice. There was the additional tranche of money that came through after the first, I think, $350 billion of small business loans was eaten up within a week. They came up with another tranche of money, and as Nancy alluded to, technical amendments in the law have been pushed through to really help businesses. The Treasury Department tried to help within the ambit of the original legislation, which gave you basically 8 weeks, and they tweaked it to make it 8 weeks, not from the day you got the money, but 8 weeks from the end of the first pay period after you got the money, which really pushed you to about 10 weeks or 10 and a half weeks. Congress has now passed a bill, which I think the president is going to sign, which extends the window all the way to December 31st, and provides a whole bunch of other technical amendments and changes both to that and some, with employment tax relief. But, the Families First Act is really the key piece of employment legislation. And that provides, basically 2 or 3 bases for relief. For employees, it provides, for the first time in federal law, paid sick leave, a mandate of paid sick leave. So 2 weeks of paid sick leave for basically 3 or 4 different situations. So if you have to take time off because you've been quarantined or subject to a stay-at-home order or a shelter-in-place order, or because you need to be tested for yourself, you can take that leave for that purpose. If you have to care for someone who is themselves subject to a quarantine order or a stay-at-home order, you can take time off to care for that person. Or if you have children who are home from school, you can take the time off, paid sick leave for that purpose. Then it also provides for an additional basis for family and medical leave, which is solely to take care of your children who can't go to school because their school is closed, or who can't have childcare because their childcare provider is closed. And then it has some relief with respect to employment taxes and the like. And there are employment tax credits that are supposed to offset the cost for the paid sick leave and the paid FMLA leave. And that's really the big employment pieces. The PPP is, as Nancy was saying, really is designed to help the businesses who've been shut down carry themselves through for what people anticipated was the reasonable period of time for the shutdown. And in some states that's worked, and in other states, not so much, because the shutdowns are going to continue. I heard this morning that Mayor de Blasio in New York has announced that they are going to enter phase 1 on Monday, and that would be, I think, June 8th. And then they will begin to discuss phase 2 or begin phase 2 in July. So New York is not going to open up very quickly, and they're going to need all that extra time that the amendment to the CARES Act is providing. So, a lot of businesses are going to be hurting and continue to be hurting. I've had the same experience as Nancy has with some of my clients not being able to get loans because they had not already had lines of business with banks. And it's somewhat understandable that, banks would want to provide, help to their existing customers, but it's been a challenge for a lot of people, and a lot of people are hurting, and those businesses need the money. And the idea behind the CARES Act and the PPP loans was to basically allow those businesses to jumpstart themselves when the shutdowns ended, basically modeling themselves after what Germany did in the 2008 financial crisis. And for some companies, it's very tough. I have a client that runs nightclubs, and they don't have a source of income right now, and they don't know when the city of Los Angeles is going to let them reopen, because basically it's a bar and a comedy club and people sitting at tables very close to each other, shoulder to shoulder, and they don't have an opening date, and they don't have a PPP loan because their bank, the bank they went to said, we're going to take care of existing customers before we take care of you. And
Right.
So it's been tough for a lot of people.
I know that in Georgia, Atlanta just reopened bars and nightclubs. We'll see how long that lasts. I want to get over to the tax conversation because, as you pointed out, Scott, there is a lot of money possibly available. We don't really know. The SBA has been a bit quiet. They do post reports on their website. You can tell how much has been dispensed under the Economic Injury Disaster Loan Program, in which states it has been dispensed. But beyond that, you may as well check Reddit for any details on how to navigate that web of information. So Jason, what are the provisions of the stimulus package with regard to taxes and any other aspects with regard to taxes? We know the IRS extended the deadline for filing. What do you see in this stimulus legislation that was particularly important with your practice and that you want to share with our audience today?
Sure. Yeah. So, I'm a tax attorney. I represent self-employed folks and businesses. And, the IRS pretty early on announced that they were extending the tax filing deadline through July 15th. And they also announced their People First initiative, which basically meant that they were going to leave all taxpayers alone through July 15th. And, I represent people who haven't complied with their taxes. So when the CARES Act came around, I pivoted into it pretty hard to help my clients. I wanted to make sure, that they could stay open and, that they received the funds they needed. But I also viewed it as a way to generate revenue for my own law firm. But I think the point of all of these stimulus bills was to provide relief to individuals and to try to keep as many people employed as possible. So some of the tax provisions from the CARES Act, which I'll focus on, economic impact payments. So, there were a $1,200 per person payment depending on your income. I had some interesting calls about that. So in order to get the payment, you have to have filed your 2018 or 2019 tax return. So I had a lot of folks who hadn't filed for a number of years come out of the woods. they changed the rules as to retirement distributions. So, if someone was experiencing an economic hardship, an individual, they could take funds out of their retirement account. So normally if you are younger than 59 and a half, there's a 10% penalty for taking the money out, and you would owe income tax on the funds taken out of your retirement account. So interestingly enough, they added a provision where you could, normally when you take the money out, you have 60 days to put it back in to avoid owing income tax. It's called like the rollover period. They changed it to 3 years. So you can take the money out and then you can defer paying tax on those funds for a number of years, which I thought was a good change. For businesses, Nancy and Scott already talked about the PPP. The payroll protection program, the only thing I would add there is it's available for, independent contractors and, solo self-employed individuals. And at this point, I still talk to people, a few a week that, didn't realize they qualified for it. And you basically need your 2019 tax return prepared. It doesn't have to be filed, but it's a calculation. Your loan amount is calculated based upon the net income shown in your 2019 tax return. And the idea is you get the money, you get this loan funds, and then it can be forgiven later. So it's effectively free money. Some other provisions, employer retention credit. So it's a payroll tax credit. I don't want to put you all to sleep, but basically if someone does not take the payroll protection loan, they're eligible to take this credit where up to $10,000 of pay per an employee can be credited against an employer's payroll taxes, which is a huge benefit for an employer. If a business had losses, they could carry them back in a special carryback provision to get a refund. And you can defer the payment of your payroll taxes. Those are really the big things. There's some other provisions that I don't think would really be applicable, but my overall take is that the point of this was done quickly. There were definitely some mistakes, but the point of it was to try to get money in consumers' hands and to individuals who needed it, and to try to incentivize employers to keep their employees on payroll.
But Nancy, maybe you can work that in, because I'd like to get into talking about how this is actually translated. You did allude to a little bit, talking about your client who was squeezed out of an opportunity to get necessary funding. What has happened between the moment that legislation was signed into law and now with respect to the gaps?
Situation. So the EDIL is actually the Economic Disaster Impact Loan. Is something that happens every time there's a hurricane or a tornado or wildfire. That is actually done more through the SBA and FEMA, and they on the fly made a decision to apply it to this situation. And there was a lot of misinformation because it was initially incorrectly done. This idea that you could get $10,000 that was completely a grant, and then they had to backtrack and say, no, we said up to $10,000, and they made it $1,000 per employee. But it is an amazing loan if you go for it, because it's 3.25% interest rate. It is not forgivable the way the PPP is. There's a lot of confusion over it, but you can get a pretty significant chunk of change, which could be beneficial if you're a going concern. And a lot of my clients are going concerns. They haven't stopped. My software clients are moving ahead. I mean, I have a client that is a lot of things that are happening on the internet right now is on their platforms. And so they don't need they don't need the PPP, but they might want to get the EDIL to use to develop something. it's payable back in 30 years. So if you got $30,000 and you did over 3 years plus interest, it's not that much money. So it's a good option. One thing that's interesting about the PPP, well, first of all, going back to the issue of the independent contractor being able to get the PPP, yes, they can, but you can't get unemployment and the PPP. So if your company, if you go for the PPP, you can't also go for unemployment, and they're going to catch those people. They've already started catching those people. So you have to choose which lane you're going to be in. And unfortunately, I know some people that went with unemployment instead of the PPP, and but they did it because they didn't want to have to deal with the accounting, which is going to be complicated. It's not easy. I shared the SBA site, which is going to be out of date once the new regulations come out for the PPP. If the current legislation gets passed, it gets signed into law by the person who has to sign it. So so it's very complicated. I, like Jason, had some clients that I got upset with who hadn't filed for the PPP, and then they got no unemployment because their 1099s don't make any sense for independent contractors. So, but I really wanted to emphasize you can't double dip. They are already catching people who are doing that. You also have to use the PPP for the intent that it was done. There's I think Lee, you posted the guy in California who had been separated from his production company, and this was a while ago, and he had already been separated from his production company, but he filed for the PPP, got it, and then his bank turned him in because they noticed he was using it to pay off debt, personal debt. But it's a great resource if it's still available, which I don't know if it is. If you qualify and you haven't already taken unemployment, it's worth looking at. It's available for independent contractors, whether or not, as Jason said, whether or not you are organized or formed as an entity, and there's no reason not to do it if it's still available. I'm very disappointed that there's no more stimulus, it seems, because we don't really know when this is going to be over. We don't know if it's going to be over as optimistically as many of us want it to be. And one last thing, and this is something I'm dealing with Scott that I would like to chat with you offline about, is what impact are these employment laws that are built into these stimulus acts that require a company to make paid time off available when it previously wasn't, including 50 days, is that what it is? 50 days of family medical leave if your kid is home from school and you don't have anyone to watch the kid. That's an expense that, yes, you get a credit for in the next year's taxes, but that's an expense you have to cover now. So as people are coming back to work, I think it's really important to think about how these expenses might end up having a negative impact on your business.
Thank you, Nancy. All right, so over to you, Scott. What are some areas that you have noticed some gaps between the intent of legislation in your area and the actual practice of the actual execution of the legislation?
My understanding was that the employment tax credit, they were going to advance it. So so they're trying to make arrangements. Jason's nodding. They're trying to make arrangements so that the companies who really need the cash flow can apply to get the employment tax credits advanced, which will then, basically use the employer to funnel money into the hands of the employees. But the whole scheme really does create some issues, including, there's I think it was part of the CARES Act, was this unemployment assistance, which is a federal program. So one of the things that they did on the CARES Act, which a lot of states had already been working on, but they made it uniformly federal, is they eliminated the waiting period. Some of you may know that most states, there's at least a 1 week waiting period where Once you're unemployed, you have to wait a week before you start getting unemployment insurance benefits. So they eliminated that 1 week waiting period. And then on top of that, they provided for a federal government program of $600 a week for 8 weeks for anyone who's unemployed. And that money goes on top of whatever your state provides. So, and you're hearing a lot about this. There was just a study that was done by the Congressional Budget Office, and some huge percentage of the people who are unemployed, which we'll get to as to why this is true, are getting more money for being out of work than they would if they were actually working. So it's because they're getting 50 or 60% of their regular paycheck through regular unemployment insurance, and then they're getting a flat $600 irrespective of what their salary or their wage rate was. And so in California, we have a surprisingly low level of unemployment insurance. It's $480 a week, I think. So in California, you get $1,080 a week, which is, you know, not a lot of money for the state of California, but it's more than the average wage for most people. And one of the things is that, you know, the shutdowns across the country really disproportionately affected a lot of low wage workers. If you think about who, you know, what was essential and what is, you know, what kinds of services people have to perform on site, you know, you're talking about wait staff, you're talking about a lot of, you know, personal services people, talking about janitors, you're talking about a lot of different people who provide services or do manual labor, so factory workers and things like that, where the factories were closed. So if you weren't in an essential industry, and a lot of people weren't, you were out of work. But if you were an office worker or, you know, a fancy lawyer who has bad hat taste and baseball caps, you could work remotely and telework from home and continue to collect, you know, most of your paycheck. And so a lot of white collar people were working and a lot of blue collar people were out of work. So I think the latest total, if you look at the number of people who have applied for unemployment insurance, it's up to like 46 million people. The good news of that is only about 21 million people are still unemployed as of this week. So a lot of people had a period of unemployment and now are back on the roll. So that's, you know, a positive sign. But you have a lot of situations like that. The other thing that where people are falling through the cracks are that you want to get people up and running, and now you have people who have all of this entitlement to leave, and so the companies can't necessarily get the workers they need to get back up and running. And the one area where Families First did a lousy job, and then I'll stop because I don't want to monopolize this, is for people who have a fear of COVID, but they don't have a diagnosis, they have not been exposed, but they're afraid they might get it, and they're afraid they might bring it home to somebody in their household who doesn't have it either yet, but maybe they're particularly vulnerable. They're over 65. They may have somebody in their household who has diabetes. They may have somebody who has some other kind of respiratory issue, and they don't want to bring it home. Those people don't fall under Family Medical Leave Act. They don't fall under the extended family medical leave. Maybe you can stay home for 10 days because you've got the, you know, so that gets you 2 weeks for some reason that you can, you know, justify taking care of them. But if they're not a child, you don't get extended family medical leave for that. And so you're in this situation where employers need the workers, and, you know, they're in a situation where, oh, can I fire them? And I'm like, do you really want to fire them? And they don't want to fire them. They just want them to work, and they don't have a way to pay them to stay home, and they need them. And it's just you know, you get all range of frustration and exasperation, not with the employee as much as just the situation, because it's a bad situation for everybody all around.
Thank you so much, Scott. That was very succinct. Jason, let's talk about where things have fallen through the cracks with the intent of the legislation with regard to your practice area and the actual execution. And possibly, you know, since July 15th is around the corner, maybe a little bit of what you see maybe coming down the pike.
Yeah, I mean, as to like the CARES Act, I think anytime you try to create something, you're not going to account for every possibility. But I think the initial bill, anticipated that states would reopen, cities would reopen faster, and I think it's being changed now. But the 8-week period was too short. And, some of the interpretation of the act by the SBA later was probably too strict. I have a lot of clients who have the money who aren't sure if they're going to be able to, get the full amount of the loan forgiven. And, are dealing with the difficulties in interpreting the SBA rules. As someone who's practicing this, it's been frustrating as the rules have changed multiple times. And, people who moves quickly to take advantage of the relief basically got screwed, or could have gotten screwed because you rely on an initial rule and it changes, and maybe to your benefit or to your detriment. But as to taxes, I mean, there is some talk about extending the tax deadline to October. So normally you can extend your tax return, the filing deadline of the tax return, not the payment deadline, to October 15th. And, a lot of people do that every year. I do, because I hate taxes and I try to defer dealing with it as long as I possibly can. So I heard there was some discussion of doing that. The extension to July 15th was a free 90-day loan from the government, because you are required to pay by April 15th, even though you can extend normally until October 15th. So I think that would be good if they do that. I think this doesn't relate to the Stimulus Act, but I do think the IRS is going to be quite aggressive whenever their moratorium is lifted. You're in a situation where there's a large budget deficit, and they need tax revenue. And I think, unfortunately for taxpayers who are in financial trouble, I'm going to be very busy after July 15th. Nothing specific, but I would just say, the execution of the acts, I think they moved quickly, tried to do the best they could, and then, a lot of the rules changed, so the guidance changed, and, they're trying to fix it now, but it's sort of too little too late. I mean, I have clients who got the loans, PPP funds 7 weeks ago, and we're going into, week 8 now, and, if the president signs the bill, it's not really going to help them in any way. So I'll be quiet now.
So that's precisely what I wanted to lead into, and you guys set it up perfectly. And of course, this conversation will probably crop up a little bit again during the Q&A. But I want to talk a little bit and do some follow-up clarification with Nancy. Nancy, let's take a hypothetical situation, building off of what Jason said about these amendments and reconfigurations of laws and procedures. Because once a law is passed, it has to be regulated, right? In the matter of, it has to be practically applied. And I think that regulation portion where a law is translated into its practical application is where the devil is in the details, as they say. And what Jason was alluding to with respect to the rules changing, I'd like you to talk a little bit, Nancy, about the discrepancy and the misunderstanding of the double dipping theory. Because for many people, they filed for every possible assistance all at the same time, not knowing or not knowing at the time that they would receive the funds. So in good faith, answering, no, I have not received an EIDL. No, I have not received a PPP. No, I have not received
there's no I didn't mean to interrupt you. There's no double dipping between the EIDL and PPP. There's a vast, you can get both. Those two, you can get both. The double dipping is if you get unemployment and the PPP.
So explain that a little bit, because I think for a lot of freelancers or self-employed persons, there is some confusion with respect to having applied for the PPP, which may have been a faster loan. And because of the enormous number of unemployment claims, you know, I wonder where would an applicant have been able to gain that information?
Well, the PPP, the intent is that you continue to work, and unemployment, you're not working. You can't get unemployment.
I will pause you on that though, because there was an exception made now on the unemployment application, with particularity to the pandemic unemployment assistance, the PUA, which provided that
get partial.
were reduced.
Right. You could get partial. You could get partial unemployment. But most people who went for unemployment didn't do partial. They went for their own self, Like if you're doing self-employed unemployment, you're going for the whole, like you want the whole thing. Partial unemployment in Georgia, actually, to be honest with you, ended up doing something very smart. And this speaks to the issue California is having with people not wanting to go back to work. In Georgia, they actually only state that did it. And I can't believe I'm saying that I think it's smart, but in retrospect, I think it was smart. They made employers file for the unemployment, for the PUA. So you had to file as an employer, even for the unemployment. I can't speak as much for unemployment, and that's really more Scott's thing because he's a labor attorney. But the EDIL and the PPP, they coexist. You just can't, disclaim your liability under both, because there was a way initially they said that you could write off part of your EDIL, but I think that's gone by the wayside. The smartest piece of advice I got on the PPP from any accountant was the advice they were giving their clients was put your PPP in a totally separate bank account. I mean, even going to the degree of setting up a new bank account. And so that your money was segregated, so that you didn't feel like it didn't get commingled with your funds that you already had, that you could segregate them. And so I think for people who got that advice or who did that, they're going to be okay with the new regulations coming in. One of the benefits of the new regulations or the new law coming in, that hopefully the SBA, I mean, truthfully, the first round of SBA regulations were, in my opinion, they negated a lot of the effectiveness of the intent of the PPP by tying it too much to maintaining your employees. And so in the new, I haven't really studied them, I've only glanced, but they did make it so that the SBA put an unrealistic cap that you could only excuse 25% of the amount that you paid used for payroll. And Jason, you can correct me on that math, but that, so basically if you spent $100 on payroll, you could only spend $25 on rent or other things that could be excused. And under this new guideline or this new legislation, that'll go up to 40%. Because what's happening is restaurants, a lot of these businesses, like your nightclub client, the PPP doesn't work because they can't maintain, they don't know when they're going to be bringing back employees. You were supposed to bring back your employees by some date in June in order to get the Paycheck Protection Act excused or program excused. Well, for places like New York, California, those places may not reopen in time to bring your employees back or the number of employees. So
Nancy, I want to pause you because I believe the percentage was 75% on payroll, 25% on non-payroll, and that's what upset the restaurant owners because it's more the other way around for them. And
so they switched it to 40%. So now under the new, you can take 40% and 60, but you still have to apply 60%. And by the way, the PPP, you don't have to excuse all of it. It's 1%. So I have a couple of clients that are are thinking about, they could take, let's say they got a $50,000 PPP loan and they end up not needing it because they survived this period. They can use that $50,000 for other things and just have a 1% loan.
But I think the other point I wanted you to make, and we can make it together, would be the EIDL is sort of where if you get both, and you say, for example, use your PPP for payroll for that 75% of payroll, then 25% you're allowed to use for something else, office rent, one of these stipulated categories. The EIDL, you would have to use for non-payroll. It's not like you can use both for the same thing primarily.
Right, but you can't, but the EIDL is not excusable.
Right,
So,
except for the advance. Now, I recall you're saying the backtracking up to 10,000, and now per employee, you only have the $1,000 that's forgivable per employee.
For up to 10 employees.
Right. So,
and I don't have a single client that got the EIDL for that.
Again, if you go to Reddit, because I surely have been, you will find a lot of testimony on that EIDL and who got 1,000 and who got 10, and it's shocking. They put dates up there; they're very thorough. Scott, I'm sorry, Nancy, did you have anything you wanted to add before I moved on with respect to how to protect, how we could protect our legitimate interests so that we don't get in trouble with all of these rules changing?
Yeah, no, it's very confusing, and you know, the loan aspect. You know, our corporate lawyers, quite frankly, have been far more involved with the PPP loans and the EDILs. I have some clients who have opted for EDIL over PPP just because they couldn't get in the queue, and there wasn't the same kind of limit on the amount of money on the just traditional SBA loans even. And so what they were doing was they were applying for the traditional SBA loans, which had a lot more requirements. Number one, it had a higher interest rate and was, not forgivable, but at least they could get their hands on the money. So I had some clients who were doing that just because it was easier. And Jason, maybe you can answer this question, because I think there is some also overlap between the refundable tax credits and what you can use it for and the PPP, and you can't double dip there either, I think. Isn't that correct?
Yeah, that's correct. The act that we're waiting for the president to sign does let you defer the payroll taxes and take the PPP, but you can't take any of the Family Act's credit or the employee retention credit. If you don't mind, I'd love to chime in on some of the things you guys were just talking about. So the EID, and first of all, you really can't get this anymore. While additional funds were made available, the application's closed. I don't know if it'll reopen. So really, we're talking about people who applied for it in, like March, April timeframe before it closed. So many folks who applied are now hearing back, and I represent some of them. And as to the advance, it was when you applied, you had to list the number of employees you had, and so the SBA ultimately determined they would give you $1,000 per an employee up to 10 grand. So that kind of dictated what one got for the advance there if they elected for the advance. My view on the advance was it was just a front running of the PPP, because if you did both, the advance is taken off your PPP loan.
Oh, yeah.
So as to like do both and how you do it and all of this, so the EIDL loan can be used for much broader purposes than the PPP loan. There's also not a time restriction to use it. So I think Nancy's advice about putting funds in a separate account, I think, is very important for the EIDL loan. So, I would make sure that the payroll for the PPP and the expenses used for the PPP are paid first, and that you use your EIDL funds later. And there are some restrictions on what it can be used for. You can't like pay off debt, you can't pay yourself and do certain things. But beyond that, it's pretty wide open. It's sort of any necessary business expense. And, I'm having consults with people now that are like, can we use this on expansion? Can I use it to hire this associate I've been waiting to hire for forever, or purchase this piece of equipment or software? And it appears that you can. So, you can do both. Unfortunately, unless they reopen it and you haven't already done it, you can't do it. But, I continue to monitor, because I personally didn't apply for it. I only did the PPP, but I would love to get it myself. So I keep monitoring. But, I think it's just a matter of making sure you account for the funds properly. Thanks.
Thank you, Jason. And we have a couple more minutes left, and I wanted to pivot one last time, if I may, please, to Nancy, because you did, is there anything else that you'd like our audience to know about areas where they can maybe watch themselves or protect themselves in the event of some more shifts and maneuvers in these laws?
Get an accountant. You may not have needed one when you were just filing a 1040 or what have you. Get an accountant. This is really a tax law. It's really a tax. All of this is going to be dealt with. I mean, maybe not all of it, but it. And if you're looking for a job, or anyone who's looking for a job, tell them to monitor things like the IRS.gov, the SBA, and truthfully, I would also tell them to monitor insurance companies, because there's so many claims coming in. So, and this should be a learning lesson. So one of the issues I've had when I was in law school, which was about the same time Scott was, there was a way to pierce a corporate veil if you were an undercapitalized company. And you couldn't just start a company back then. If you didn't have resources, it wasn't so easy. The LLC is only a 30-something-year-old institution. And I think that there are too many people who start companies that don't have the wherewithal. I think there are too many freelancers. I think we've as a society have moved too much into this idea of the 1099. And the reality is, a few years ago in 2015, the Department of Labor, U.S. Department of Labor, came out with a very strict guideline about how they did not believe most people who claim to be independent contractors are independent contractors. In their opinion, most people who work in this country in any capacity are employees. And there was a lot of conspiracy as to why they came out with that. Was it because of Uber and Lyft? And it wasn't. It was because of the ACA. It was because of the healthcare law. And that's the reality. I think we have to revisit how we start companies, how we run companies, how we treat staff. Are we being realistic that someone's really an independent contractor? I worked on the Clinton campaign in 1992, and my dad was a CPA, and he said, and I was being paid like an independent contractor, and he's like, "You're not an independent contractor. You don't control your schedule. You do," like he just went through it, and we've just completely created this whole gig economy and all that stuff, and I think we really have to revisit it. So if you have a company and you've gone through this period and you're wondering what to do next, I say really use this time to take stock of where you are. Make sure you have the resources to be doing what you're doing, to pay your employees the correct amount, to be, are these people really independent contractors, or are they really employees? And I actually applaud California. I know it's very controversial, but I actually think California did the right thing. I know it's controversial, but I'm going to stick with that.
Scott, I would love for you to give your closing comments, pivoting off of what Nancy has shared with us with respect to final words on what folks can do to protect themselves.
Yeah, counterpoint, I think, is my position. You know, I appreciate Nancy's view, but I have a completely different perspective, particularly since California decided they were going to rewrite 350 years of Anglo-American jurisprudence on employees and independent contractors. I will agree with you, Nancy, that I think a lot of people are under the misimpression that you can just simply decide that you'll give somebody a 1099 and make them an independent contractor with the wave of a pen. And I will also agree that, you know, the independent contractor employee test that is traditional common law test it's a hash. It is a very difficult fact-specific test that makes it very, you know, hard for people to properly classify people. But that's been going on for 45 years. There's a provision, I'm not a tax lawyer, I don't pretend to be one. I'll leave that to Jason, but there's a provision in the 1978 omnibus budget resolution, which basically prevented the IRS, or tried to prevent the IRS from going back and reclassifying workers, because the IRS was being overly aggressive in saying that people who were independent contractors were really employees. And so it's a fight that's been going on for a couple of generations now. But you know, the idea that somebody is an independent contractor is a legitimate and you know, distinction in the law. And you know, you can look and see whether or not somebody is an independent contractor or employee, and sometimes it's a Gestalt test. It's, you know, the actual test is a 18 or 20 factor test. No particular element predominates, and it's the totality of the circumstances. And I can show you cases where the same classification of people under very similar facts are found to be employees, and some of them are found to be independent contractors. In fact, in the animation industry itself, there are two cases involving an animation company, Deke. And I worked on one in 1988 and 89, and they found that the workers at Deke were independent contractors. 15 or 20 years later, Deke had changed ownership, and a different lawyer handled the case, and they found the very same workers to be employees. And so it's a tough test, but you know, there are a lot of workers who prefer to be independent contractors a lot of times because they have better tax consequences for them, or they can write off, you know, more expenses, or for whatever reason. And talk to your Uber and Lyft drivers the next time you take one and see what they think. You'll get a lot of different opinions. A lot of those people actually own multiple cars and have drivers working for them. So it is an entrepreneurial kind of environment. You know, and I'm that 2015 DOL memo just made me, you know, see red and rip my hair out when I had more hair than I have now.
That is hysterical. I have to send you my memo I wrote on it, which was basically laudatory. I might be the weirdest socialist that ever existed. All right.
So I will mention on the point of, and before I get to you, Jason, for your final comments on the issue of independent contractor versus employee, one more little point, juicy point that may not be in your memos is the whole ownership of intellectual property fact. You know, that employees, by virtue of their employment, cede ownership of all of the results and proceeds in their work to their employer, whereas independent contractors actually have to sign an agreement to the effect of, you know, it has to be a work made for hire. And so whether somebody's an independent contractor or whether somebody's an employee, depending on when that was decided, may affect that aspect of their work. And as we know, a lot of these cases come up with comic book artists, especially with pre-existing properties that are now being produced into blockbuster franchises and merchandise. So maybe that's a topic for next session. Jason.
Yeah, it's a great topic, Lee, and it's a great topic. It's very often overlooked, particularly by small companies. They don't focus on those distinctions, And by the way, it's not something you can simply paper over and get the parties to agree. The Supreme Court has said it's the facts on the ground that determine that.
Oh,
So
yeah.
it's a great
So
topic.
we'll definitely dive a little bit into that in the next session. Closing comments from you, Jason, with respect to what can our audience do to protect themselves with respect to these tax bells and whistles that came down through the legislation?
Yeah, I guess if you haven't taken advantage of anything that's available, you should, and it probably involves reaching out to an accountant, a CPA, a tax attorney, or someone who's assisting, with this type of work, because it's unfortunately not straightforward. There's a lot of good information on the internet, and I know Reddit's been mentioned. The Tax Policy Foundation, the U.S. Chamber of Commerce has actually had a lot of great information too. But yeah, and then I would say, as a side note, I think there will be another stimulus bill, and I think it passed the House or something good, and call your congressman in the Senate if you want further relief. But beyond that, I don't know there's much you could do. I would add to the lively independent contractor comment that I will never work for anyone else again, but if I did, I would negotiate to be an independent contractor. So I'm just going to put that out there.
Thank you so much. And thank you to all of our panelists for doing such a great job. Typically, if we were in real life, I would ask our audience to give a little round of applause for your participation on tonight's discussion so we can all clap into our screens. But let's now proceed into the Q&A portion. And I did ask Ginger and Andrew if they would please field questions from our audience, and certainly please feel free to, if you feel like being in front of the camera, or you can chat me the question, you can ask on behalf of your members. So Ginger, would you like to start?
Actually, I think Andrew fielded some right now first.
All right, so I think we're gonna go to Andrew.
All right. Well, I think the most important comment in chat is reflective of a few of them. From CJ says, clap, 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 clap. A lot of praise in chat for what's happened. I thank you all very much. All right. One of the questions I'd gotten from my members in a survey, and I've rephrased it a little bit for them, is in regard to paying back EIDL and PPP. Can you pay it back early to avoid interest payments on the parts that aren't going to be forgiven or were not grants?
I think anybody who wants to grab that one, you just go for it.
Yeah, there are no prepayment penalties. You can pay it back.
Yeah, you won't have to get the full interest on it.
Like accrued interest, that you'll owe, but you can pay it back. Yeah.
All right, that was the main one I had received.
So I also have one as well too, especially for a lot of, like you said, animators and artists that are on 1099 contract. They ask if there's anything that's different for filing for unemployment, or just any difference in terms of like unemployment benefits, or is it more difficult to file than other classifications of workers?
Yeah, I think that's probably going to end up on my lap. Unless, Nancy, do you have a view? Or because unfortunately, my practice is generally directed at employers, not employees, and so the actual mechanics of unemployment insurance applications, I get the responses that the employers have to give. I think that some states are struggling with how to apply these things to contractors, because previously contractors never had the ability to get unemployment insurance.
Sorry.
Go ahead, Nancy.
Nancy, did you want to jump in and talk about the question that Ginger had? Ginger, did she need to repeat the question, or?
No, I mean, it's the mechanics. So it's prior to this pandemic, if you were a 1099er and you had no work, you just had to live off your savings. There was no unemployment insurance. And so recognizing that if the entire economy came to a screeching halt, that people who were 1099ers were going to be in a very bad situation. They extended unemployment for the first time ever. And that really was that was probably one of the hardest parts of this whole thing, because the states had no methodology for handling these applications. And so I think, if I recall correctly, they're called PUAs. And what happened is people who were 1099ers applied immediately, like people who had, got laid off from Shake Shack the first day, before there was a furlough policy, which is a different story. That's a political thing, sorry. Bitter not. And so it's been a real struggle for the states to figure out how to do it. The good news about unemployment insurance is that it's retroactive. So if you don't get it immediately, like when you file, when you get it, it gets applied retroactively. So you need to go to your state's unemployment website at the Department of Labor, and you have to follow their instructions specifically for 1099ers. Every state has them now. And at this point, if you haven't filed, I'm not sure how much longer that $600 bump is going to be there, but you need to go ahead and file.
So the $600 FPUC, Federal Pandemic Unemployment Compensation, I think that's what it's called. It lasts, technically, it is April 4th, and it is claimed once per week, and it is available until the end of July. That is the uptick $600. If you are qualifying under the Pandemic Unemployment Assistance. And in order to qualify, you have to first be rejected by the state unemployment. So at least in Georgia, that's the situation. So it's very counterintuitive. You have to first apply for good old-fashioned state unemployment, be rejected through that process, which takes some time, and then be invited directly to your email to participate in pandemic unemployment. And then it's a completely different process. They actually waived the requirement to look for a job on the state unemployment, which typically requires that you provide proof that you're seeking employment if you're claiming loss of wages. So if you're rejected, you apply for pandemic unemployment. Then that kicks in what Scott was referring to with California having a limit of 468. In Georgia, and again, it's different in each state. In Georgia, the maximum amount you can qualify is $365 per week. So the federal uptick, as Nancy was saying, kicks that up to $965. And so, but that's limited. Now, the federal, the stimulus legislation, typically in Georgia, you get, I think it's like 30 weeks, maybe 28 weeks of unemployment checks, but the CARE stimulus package kicked that up another 13 weeks. So you could easily have applied for an insurance, say, right after the stimulus passed in March, like in early April sometime, and say you had to go through the rejection period and come back and try for pandemic unemployment. And again, every week is not required, but if you want the money, you have to do it. Then you could easily see that approval window go from all to the end of the year. So it's almost like, it's again, each case is unique. I don't think you can really learn, you can learn a little bit about the stimulus from this panel, but the best direction that I would like to leave our audience with who has these types of questions is to establish a relationship with an attorney and or a CPA, as Nancy says, and to really talk to them about your specific situation, because there's a lot of really little details that may completely change your options. Everything from your tax status, because even registered companies can be regarded as disregarded entities. So there's a lot of details that you will not be qualified to see, which is why having a CPA or a lawyer helping you is very, very important. And now I will get off my soapbox. Do you have another question?
Yes, there's another question from CJ is what advice are you recommending to clients, gig freelance 1099, who may owe tax after filing for 2019 but will still be unemployed after the UI or any other assistance have ended?
So this is what I do for a living. I represent people who have tax liabilities they can't pay. So with that scenario, I'm just going to give you some advice and suggestions. So with that scenario, I would extend the tax return until October and kick the can down the curb as long as possible. Do not file. You need to file on time. If you can't pay it, still file on time. The Internal Revenue Service charges a 5% per month penalty for every month that you were late. So you should avoid that penalty if you can. I get people are afraid when they owe the government money. You know, it's the federal government, they're big and scary, and they're going to, you know, you probably believe they're going to put you in jail or do bad things to you. It's not really the case. I mean, they can do bad things to you, but it's typically not as bad as people or clients and leads I speak with believe. Everyone's situation is different. There are a lot of different programs that exist. Sometimes you can settle the tax liability. Sometimes they will put you into statuses where you don't have to repay them at all, or at least temporarily until your financial situation improves. The strategy that you ultimately employ is dictated on, you know, what we think the future will hold, you know. So if you know, if you were doing very well before this happened and you think once things return to normal you'll be doing very well again, I would typically take the position that we need to strike while the iron's hot. And in my world, it's like opposite land. You know, when things are really, really bad for the client financially, that's when I get them the best deal. Which is not intuitive. I find that I get a lot of people who contact me once their financial situation improves and they save up money and they're like, okay, you know, I want to go to the IRS and try to work a deal with them now. And that is not the time to do it. You know, but they have payment plans. Worst case scenario, they have payment plans. They'll give you like 6-7 years to pay it. It's your first time having a tax liability. They will waive the penalties you owe. So when you tax return on time, but don't pay what you owe, they charge a late payment penalty that is a 0.5 percentage point per month, up to 25%. So they waive those penalties if it's the first time you've had an issue. So I could go on and on and on forever because this is what I do for a living. And I'm a crazy person who enjoys dealing with the IRS all day, every day. But yeah, it's very fact specific, situation specific, and your financial circumstances now and in the future really dictate everything. So thanks.
Do we have more questions from the audience, from either Andrew or Ginger?
Well, I'm just going to say, join us this weekend for SimFest for the Game Dev live streams. We'll have more on the business side of game development. Check it out, ggda.org.
Definitely. And I also wanted to mention that these wonderful speakers have also prepared resources. So I would like to point that in our link below, we actually have aggregated all these resources from the different speakers to put inside of our like COVID-19 resources. Please definitely check them out. They will be very useful. And if you need any information about our participants, those will also be available in the resource as well.